Right, we can go back on the record. I'm sorry about that, but I had to get an order done. Yeah, it was a decision on like 5 motions. It was ready to go and I wanted to make sure it was published today. So,
No worries, John. Thank you for accommodating us today.
yes.
We're making good progress. Wave it, Teddy.
Okay, gentlemen, where do we go next?
Your Honor, we show that the next one on the court's calendar would be docket 526, Rural Water's motion in limine to include lay opinions from witnesses. This is motion in limine number 5.
What about number 4? Did you?
4 is, I don't have
You guys-
4.
525. Yeah, 525.
And this 4?
Yeah.
Oh, a copy and paste error on my part. Oops.
This was one that, yeah, it was,
Let's docket. Do you have the docket number?
Yeah, 525.
525, sorry. Who has 4? Is that me?
I think that's that.
Okay. And I guess Mr. Kaufmann will be presenting for us. Now are you back?
Mr. Kaufmann? Press *6.
Sorry about that. My computer froze for a moment. Okay, sorry. Actually, Your Honor, I was based on what we discussed about motion and rear water motion eliminate number 3. I think the same rationale and outlines would apply, about it's mostly about the jury verdicts and the awards, and which plaintiff has already agreed to not to discuss. So I don't think we need to have too much discussion on this.
All right, well, tell me this. Where did that put us as far as my decisions are concerned? Because the real big issue is our court clerk has to know what to note in the minutes, right?
Yes.
So I don't want to step on your toes, Matt, but I believe what he's trying to say is that this motion can be similarly denied or granted in part and denied in part based on the previous stipulations of the parties, that we would not offer any evidence about the jury verdict specifically or the judgment specifically. But similar to the motion that Mr. Parker and we discussed earlier about the individual claims and the individual plaintiffs and the facts related to the plaintiffs, those are not excluded based on the court's previous ruling. So anything in the motion that would target that would still be denied, but it would be granted to the limited sense of the jury verdicts and the judgment specifically.
That's correct.
Okay, that's what it shall be. And you can go over to Tori just to make sure you understand.
So it's granted in the limited sense of the jury verdict and judgment.
The 3 previous jury verdicts and the 3 previous judgment amounts, yeah. Judgments and judgments amounts.
From the prior trials.
Understand. Thank you, Your Honor.
And denied us to the rest.
Yes. And that would be the other, denied as to their individual injury stuff. All right, so next up will be.
That's 526.
Yeah, docket 526, Rural Water motion in number 5.
We actually started docketing like that numbers wise in real water. This makes it easier to follow.
Yeah, it really works well.
Right, so
Basically, this motion in limine is that lay witnesses cannot provide testimony regarding medical opinions and causation. Just like plaintiff's motion in limine earlier that was granted precluding lay witnesses from providing scientific testimony. This motion is just like that in that lay witnesses can't provide medical testimony.
and I don't want to cut you off, but this would be motion in limine number 4.
5.
5, okay.
Yeah, 5
Okay.
and 5 docket number 526. Lay witnesses should only be allowed to testify to the physical symptoms that they experience or observe. In this case, plaintiffs are alleging injury to internal organs. This alleged injury can't be determined without medical training and medical testing. The causation is not physically observable, and plaintiffs should be precluded from testifying about that as well as other lay witnesses. They shouldn't be allowed to testify as to their beliefs and assumptions as to these medical opinions. Plaintiffs have raised prior complaints and have asked these lay witnesses if they believe real water, if their injuries were related to real water. And three in particular, Lois Kessler, she claimed that real water caused her fatty liver disease. And despite the fact that she had already been diagnosed with fatty liver disease before consuming real water. Robert Fisher, he claimed he had a liver injury, and his diagnosis was metabolic alkalosis because of excessive water intake, it was not a liver injury, and it was not diagnosed, but he still offered that opinion testimony. Susan Doran, she claimed that her family all suffered liver injuries from real water, despite the fact that no one sought any medical treatment and no one had any medical diagnosis of liver injury. All of this testimony that was elicited is based on assumption. It's not based on any type of medical evidence or opinion from an expert. They're not doctors. They don't have any special knowledge to make those opinions. And therefore, the court should prohibit plaintiffs and lay witnesses from testifying regarding opinions on the cause of their symptoms, medical diagnosis, and future medical needs. This would mislead the jury to allow lay witnesses to testify to this. It would be unduly prejudicial. That's the basis of the motion. Thank you.
Thank you, sir. Mr. Pepperman. Good.
So, Your Honor, first of all, the request on the motion to eliminate is overly broad. I mean, they're just making blanket statements for the most part that lay witnesses can't give medical opinions, and that's a follow the law type of request, which if there's a witness on the stand that is giving a specific opinion that they contend is a medical causation or expert opinion, they can raise the objection at that time and the court can rule on it based on the actual specific testimony that's being offered, not some blanket rule that we don't know how they're going to interpret whether the motion to eliminate order applies. So it's first reason why this motion should be denied is because it's procedurally defective. That's under the BMW v. Roth case that exclusions and preclusions have to be specific, and this motion just is not for the most part. The only specifics that they really offer related to the testimony of Lois Kessler, Susan Dorn, and Trey Fisher. Your Honor, this has already effectively denied this same motion because these three witnesses testified in the Gallagher trial. They made the same motion in the Hun-Wartson trial. It was denied. The same three witnesses testified in the Hun-Wartson trial. They made this motion in the Wren trial, which was denied, and these same witnesses testified in the Wren trial. These witnesses, they submitted written complaints telling defendants that they suffered adverse health events after drinking real water. Your Honor has already denied the motion.
That's a different issue. Like any prior complaint, symptoms or something like that, that they suffered as a result of ingesting or drinking real water. that would come under the 6 potential exceptions that I talked about. This is slightly different as it relates to the thrust, scope, and the type of potential harm they suffered as a result of their ingestion of real water. And what I mean by that is this: I think he brought up one point, and I do agree we have to have some particularity. For example, would the plaintiff be able to testify I suffered a fatty liver injury due to my ingestion of real water? That might be another animal, because that's not like breaking a leg. That's, yeah, I fell and I broke my leg. I can see my bones sticking out of my my femur sticking out. You know, you see where I'm going on that?
I completely see where you're going with it, Your Honor, and that's my point. Is these witnesses, they did not testify as to anything beyond their own personal observations in the case, and we know that.
Well, yes, observations and experiences.
Right. That's all these witnesses are testifying to. And we know that because they've already testified 3 times in 3 prior trials. We've done the deposition designations. None of the deposition designations were anything close to a medical opinion that would be impermissible. They were all factual. They were all facts as observed by the witnesses related to their personal knowledge and experience. And it's been played 3 times. So nothing that they are going to testify to has anything to do with impermissible medical causation opinions, because we've already gone through this 3 times and played it. We know that it's not impermissible medical causation opinions. They're all facts based on their own personal knowledge, which are permissible, which is why they've been allowed to testify to them 3 times. And that's why they're being offered, because they submitted a written complaint telling the defendants that they suffered adverse health events after drinking real water, and they were deposed about the facts surrounding those events. Whether they're saying, first of all, the statements about what they were testifying to aren't accurate. I know Mr. Fisher, he never said, I suffered a liver injury from this. He said, I drank real water. I was sick for days. I went to the doctor. This is what the doctor told me. This is how I felt. This is what I wrote to Real Water. Real Water never followed up with me. They never did an investigation. They never asked to see my medical records. That's what he testified to, and that's the purpose of his testimony. He didn't say anything about, I diagnosed myself with this, ailment that I'm not qualified to diagnose about. It was solely his personal experience with Real Water, and that's based on what he communicated to Real Water. We have the emails, we have the written complaints that were submitted to Real Water. That's already been pre-admitted. This testimony just is the factual testimony surrounding that. So that's why the specifics matter, Your Honor. Based on these broad brushes, we can't exclude any specific testimony that's not before the court, and they haven't brought any specific testimony before the court. If there is someone who's going to testify and they're going to say something impermissible, or they're asked a question that elicits an impermissible medical causation opinion, then they can object at the time of trial. Nothing precludes them from that. But there's nothing before, Your Honor, that supports an order in limine on a specific piece of evidence that is impermissible medical causation testimony. And again, Your Honor, I can't stress this enough. These 3 witnesses in this case, they're not going to offer we're not going to play any deposition testimony that hasn't already been played 3 times. So this issue has been looked at and considered 3 different times by 3 different courts, including Your Honor, and there's been nothing found to be impermissible with respect to the deposition testimony that we would play in this case. So on that basis, we'd ask the motion be denied.
Okay, thank you.
Yeah, Your Honor, we differentiated the difference between a witness testifying regarding physical symptoms that they experienced, and there was a clear difference between that and giving medical testimony. plaintiffs are asking these witnesses if they believe they had injuries related to real water. And in the reply, we list out several different questions that are answered. And one specifically is Lois Kessler was asked in her deposition, do you have a suspicion that the real water was the cause of your liver problems? For her to answer that is offering a medical opinion. She's not saying what her symptom was. She's not saying, well, I felt this or that. They asked her, was real water the cause of your liver problems? And that's outside of the scope of a lay witness. Thank you.
All right, what about that?
Well, if we look at the specifics in the reply, starting with Susan Dorn on page 6, they ask her, the testimony they cite involves, did you have occasion to have your liver enzymes checked? No. All she's doing is testifying is, I didn't have any liver tests. My answer is, I didn't have my enzymes checked. I didn't have I don't know if I had ALT or ASTs. Those aren't medical opinions. Then the next quoted testimony from Trey Fisher on page 7. Have you had any symptoms that would suggest to you that maybe you have something slightly wrong with your liver? Not that I'm aware of. No, that's not a medical opinion. He's saying I'm not aware that I have any liver injury. Did you have any darkness in urine, tenderness in your liver area, anything like that? No. What's the medical opinion there? I would think they would want that in there. Kessler, maybe if there's a page citation, I'm not seeing.
The one I read was on the bottom of page 5, Eric.
As a reply?
Yeah.
Take your time.
Well, Your Honor, I mean, on the bottom of page 5, they quote a question. There's no testimony regarding an answer from the witness. So that's exactly my point, is I don't have the full testimony in front of me. To the extent
These were questions asked by the defense during the deposition?
Correct.
Okay. All right. I mean, I can say this in a general sense. I would anticipate we won't have lay individuals opining on injury causation to a reasonable degree of medical probability. When it comes to potential symptoms they experienced, ailments they might have suffered from, or any physical problems they had as a result of drinking real water, they can opine on that. They can give their testimony. And so if that's the call of the question, when it comes to medical causation opinions, of course, lay people can't testify, right? Especially in this case. I mean, there are exceptions like the compound fracture, right? That's an exception. I get that. But this is a little bit more complex than that. I'm not saying it's not complex to repair a compound fracture, but the obvious cause, you fall off a bike, you suffer a compound fracture, you can see it.
Exactly, Your Honor. That was the reason for the motion. It was and based on some of those questions from plaintiff's counsel that we want to avoid.
Yeah.
Trying to
So
elicit
in general,
that
I mean, I don't really think it's a big issue at a trial, but in a general sense, we all know that when it comes to medical opinions and diagnosis, you gotta be MD, PL, something like that. Granted, subject to those qualifiers. I'm not going to exclude any of the potential plaintiffs or others from testifying as to their symptomology or whatever ailments or injuries they might have suffered that they felt physically. But that's different from giving a medical causation opinion. What's next?
527, real water motion limit number 6 for rocket fuel.
Didn't we have this one before?
You have heard this one before, Your Honor.
I'll be quick.
No,
Basically,
that's okay. No, you gotta make your record. I get it.
using rocket fuel interchangeably with hydrazine, the only purpose for that is to inflame the jury, evoke emotions, and it's all prejudicial to real water. The uses of hydrazine are completely irrelevant. Hydrazine is in a lot of different products, and one of those happens to be rocket fuel, and everyone knows why they decide to use that one because it is so inflammatory. Plaintiffs failed to address the issue of real water or of rocket fuel being inflammatory to a jury and how it's improper character evidence. Instead, they focused on unrelated cases where the court talked about rocket fuel. Well, that case was a case regarding a factory that produced or used rocket fuel. So it's completely out of context. There is no benefit or need to call hydrazine rocket fuel. Even if there was some benefit of that, it's substantially outweighed by the prejudicial effect that type of those words elicit. And so it's inappropriate and unnecessary for the use in the courtroom. Thank you.
Thank you, sir.
Your Honor, in our opposition, we point out that the scientific literature calls it rocket fuel. The case law calls it rocket fuel. And the defense experts in their reports called it rocket fuel. In their depositions, they call it rocket fuel. Everyone calls it rocket fuel because that is the primary use for hydrazine. And so basically, a rose is a rose. You can call it a rose. Same thing with rocket fuel. I think, from the last trial, we didn't, they were worried. Last trial we started out with, they didn't want to talk about World War II and Germany's rockets and Nazi bombs.
That's true.
That's where they started this. And we said, fine, we won't use any of that terminology because it could be unduly prejudicial. And now they're taking another step forward. They're trying to get pure rocket fuel. So I don't see any problem with this one. And I urge the court to adopt the same ruling that it did last time in response to this motion. Last time this was motion in limine number 8, and we've quoted it in full in our opposition. The orders to be quoted. Yeah, Judge, and before I forget, Judge Hardy and in the Hunsworth case, this motion was denied both cases. We called it rocket fuel then too.
Last words, sir.
Nothing further. Thank you, Your Honor.
Yeah. And which one are we at again? I just want to make sure I get it right.
6.
It's Real Waters motion in limine number 6, docket number 527.
All right. And that's Real Waters motion in limine to preclude plaintiffs from referring to hydrazine as rocket fuel. And I think this is often overlooked when we discuss evidence. All evidence is prejudicial to one side or the other. Right? That's how it is. But the real issue is whether it's unduly prejudicial. That's what the case really discusses. When I look at this case, at the end of the day, what is hydrazine used for? Rocket fuel. That's what it is, right? And there's no way to color code it. It's a pathogen, right? It's hydrazine. It's used primarily for rocket fuel. What else would it be used for? And you don't expect for hydrazine to be in water, right? You just don't. And so I'm going to deny it. And for a lot of the prior reasons I said in the other trial, but it's rocket fuel, and they actually use titanium tubes that potentially had hydrazine residue in it, or I don't know how. I mean, chemically, have we made a determination as how that?
Yes, Your Honor. 2 different ways that Dr. Najam theorizes the titanium reacted with.
That's kind of where I'm going. Yeah.
Not mutually exclusive. It could have been both.
Yeah. No, I get it. It's one of those things that unfortunately happens. So after that, we're at,
We show 528, Your Honor, motion eliminated, a real water motion eliminated 7.
to preclude pathology reports and results from non-plaintiffs.
Yeah, I think the next 4 are gonna be quick. The next 4, the court has decided all or part of. But I think it's best to take them one at a time.
Okay, so I guess this would be,
Docket 528.
yes, Affinity Lifestyles and Real Water's motion and limiting them to preclude pathology reports and results from non-plaintiffs.
That's right, Your Honor. This concerns Dr. Datnow. We've talked about Severin Morales from the Hunwertson case. We brought this motion in limine to confine Dr. Datnow's opinions to the plaintiffs in this case and to also exclude opinions regarding the Burke article. I think the court has already touched on this, if not already denied this motion, but I want the record to be clear. So certainly I'm happy to elaborate, but it seems to us the court has addressed this, but anybody, I guess, doesn't believe the court's addressed it, they can speak up. I believe the court's addressed it.
Judge, when we pre-admitted the Burke article and we discussed Severin Morales and tissue slides and the relevance of those, I think this was denied. But for the record, I agree with Mr. Odou that should be denied.
All right. Anything else, Mr. Odou?
No, Your Honor, we would incorporate all our arguments from the prior motion in limine and understand the court's ruling.
And I'm gonna do that. We can move on to the next one. We're at, and that's Affinity Lifestyles, DBA Real Water's motion and limiting them to limit lay witness testimony.
Yes, Your Honor. Thank you, Joel Odou, on behalf of the Real Water defendants. This motion has slightly been touched on previously. Make sure I get the right one in front of me. I'm sorry, Your Honor.
Number
I
5.
pulled up the next 4 in a row. And I put the wrong one in front of me. That's probably my pen.
Number 5.
And this is docket 529.
Yeah, I have motion limiting number 8. This concerns Dosatel. So, Your Honor, we've talked about Mr. Dosatel today. I'm gonna go, I need to get up and touch my back. Your Honor, as we put forth in our motion in limine, Mr. Dosatel's job was not to receive customer complaints. Plaintiffs asked him a hypothetical. If you knew about this, you would have shut down the line. If you knew about this complaints, you would have shut down the line. Oh, yeah. He's 2 problems with that. 1, he's speculating. 2, it's not his job. 3, he didn't have the authority. I guess that's 3 things, isn't it? The authority to shut down the line. He wasn't even working there at Real Water at that time. So this is speculative testimony from Mr. Dosatel. Mr. Dosatel also provided speculation testimony.
Is this the gentleman that worked at Nestle?
No, that's
This is the Army gentleman, drill sergeant.
remember he came live, Your Honor.
Yes.
Yeah, he's come live to all the trials. He's
Was he the production gentleman involved in production?
he ran the production line. So basically they filled the 5-gallon bottles. And even though he was a quality control director, it was over the quality of filling the bottles. That was his role. Plaintiffs have made a big deal that these were his duties, but we quoted in our motion, his duties were to make sure people show up on time, make sure people on the floor are working the line, the water line, ensure the equipment was kept up with the maintenance person, make sure orders were produced in a timely fashion and meet demand. So he was a supervisor. They said, okay, so they called you director of quality control. He says, quality control of operations or production. In no way was I anywhere near that. So Mr. Dosatel obviously left Real Water on less than stellar terms. But again, in court today, even they've argued that Mr. Dosatel would have shut down the line. Well, that's no different than arguing any of us would have shut down the line had we known whatever else. And so that's just not appropriate. It's speculation. He's not an expert witness. He's a disgruntled former employee that worked there in 2016. So for him to say what would have happened in 2018 or later is just speculation, and it's also hearsay, and it lacks any indications of truthfulness. He's 2020 hindsight. We also challenged his hearsay declarations regarding his dogs. As the court will recall, it wasn't funny. It was kind of sad. Mr. Dosatel blames the death of his dogs on real water. One of his dogs fell in the swimming pool and drowned. And the other dog passed away at age 14. Again, he believes in his heart of hearts, I guess, that real water killed his dogs, but he would like to, and this is subject to a later motion to eliminate about pets, but this is all hearsay. And there's no way for us to cross-examine him about his emotional attachment to his dogs or what happened to his dogs nearly 8 years ago now. So all of this testimony of Mr. Dosatel is hearsay. There's no exceptions. It's speculation. Patty Converse also was a former receptionist at Real Water. She was given a job title. They want to offer speculation from Patty Converse to make it seem like, oh, well, she wasn't able to enter the concentrate room, therefore something nefarious was going on. Well, that's not true. She just was not, that was not part of her job duties. They make a big deal because she was responsible to look for loose cords on the floor that were electrical that somebody could trip on, or because of water issues, but she wasn't allowed to go in the concentrate room to do that job. Apparently, nobody could look on the floor and look and see if there were loose wires or trip hazards. So again, they want her to testify about what happened in 2017, 18, 19, and 20 when she left the company, after she left the company. And that really is speculation. They also have a claim that because there's a electronic signature for the HACCP program, she says she doesn't recognize the signature, implying that it's forged. Again, there's no evidence of that. And frankly, it's not even an issue left in this case because liability is not contested. She didn't review customer complaints. They want to ask her about customer complaints. That's just speculative, improper testimony. And so we think those should be excluded as well. So even if the court finds any of this testimony to be relevant, which it isn't, it's still based on speculation. It's still prejudicial and it should be excluded. I think that's all of the categories. And like I said, the court's kind of touched on this, but we haven't hit the issue square on the head yet. And you've heard this motion before.
Okay. Thank you, sir. Mr. Pepperman.
Yes, Your Honor, you have heard this motion before and you denied it before. Just as Judge Kitchener and Hunwortson and Judge Hardy and Wren, and for good reason. And respectfully to Mr. Odou, he's clearly getting more desperate with this one because that argument was pretty outrageous in the sense that the Real Water hired and held out Mr. Dosatel and Ms. Converse as their quality control directors. It sounds like Mr. Odou is admitting that they were fake quality control directors, but regardless, their jobs were to review the customer complaints according to Real Water as they held them out to be. We know Ms. Converse was hired initially as a receptionist and I think a month or two later hired as the quality assurance director with no experience. She testified extensively about the customer complaints that she received while she was there. She was on many of the emails giving cases of water in response to the emails. Mr. Dosatel testified about the quality or the customer complaints that were submitted when he was supposedly the quality control director at Real Water, testified he'd never seen them, and testified that they were significant problems, and had he seen them, he would have shut down the production line until they found out what was going on with this water. These are all, none of this testimony has anything to do with expert opinions. These are based on their personal knowledge and experiences while they're employees at Real Water. Everything that Mr. Odou said is pure argument that Real Water wants to make to minimize this testimony, which is their right to do, but they have no right whatsoever to unilaterally, based on these frankly absurd characterizations of the testimony, exclude relevant evidence. And certainly nothing that he said establishes that any of this testimony is impermissible expert testimony. Their argument in the motion is literally a paragraph. It's 12 lines on page 12 and does nothing to give this court any reason to change its prior ruling on the same motion. And we would urge Your Honor to deny this motion as you did in Gallagher.
1 second. Your Honor.
No, take your time, sir.
So it's, reply. It should be in what we signed there. You don't have a reply brief? Yeah. No worries, it's all good.
Big foundation.
There we go. We're in business. Thank you so much. Sorry to put you on the spot. Thank you, Your Honor. That's trying to put it for the court exactly what we're talking about, which is an excerpt from the deposition of Jeffrey Desitel. This is not Joel Odou making it up. This is not Joel Odou getting desperate. I've heard this testimony so many times I can practically recite it in my sleep. Again, plaintiff Mr. Pepperman just represented to the court that this is made up. Well, okay, here's the question. It was your part of your job to receive and investigate customer complaints, if any. No, it was not mine. Okay, that was the front office. Answer, okay. So that wasn't part of your job. No, that's taken from the deposition of Jeffrey Desitel, taken by the plaintiffs in this case. The citation appears at the bottom of page 7, page, line, reference, chapter, and verse. So we've heard this testimony as to what he would do about customer complaints. It's been allowed to come in over the objection of Real Water, yet we have argued a number of times, and now we have provided proof that it was not his job to hear customer complaints. So whatever Mr. Desitel says in 2023 and 2024 as to what he would have done in 2016 is completely irrelevant and is speculation. Plaintiffs acknowledge he's not an expert, so that should take care of that issue. As far as Patty Converse, she again was not the person that was HACCP trained. We've since learned in one of the other trials who was HACCP trained, and it's not Patty Converse. So for her to offer any speculation about her being underqualified for her job or filling over her head doesn't matter, because that wasn't her job. She was a receptionist. And let me say something about the way Real Water ran their business. They've been heavily criticized frequently in this court and others about the way they ran their business. There's a number of ways people can run their business. People can choose to give people job titles. That is a business philosophy that some people have. They give people job titles. They give attorneys job titles, partner, associate, paralegal, assistant, whatever. Patty Converse had a job title. Jeffrey Desitel had a job title. His job title doesn't mean that he is an owner of Real Water. It doesn't even mean he's the director of quality control for the entire company. He was the director of quality control for the production line of filling bottled waters. And the fact that he didn't have the authority to stop the line, the fact that he didn't even receive complaints to ask him to speculate as to what he would have done is just improper. And it's the same is true of Patty Converse. Plaintiffs need to lay a foundation for this testimony. This testimony has all been presented. Well, Dositel's come live. Patty Converse apparently is avoiding service, or at least the last two cases, three cases, we've been able to get her. And so her testimony is not subject to cross-examination. She's not available. She just doesn't want to see us. So we think this is hearsay testimony at best, speculation at worst, and it should be excluded.
Was her deposition taken?
Yeah, Petty Converse was deposed and then disappeared. She's local. And my understanding, and I'm not speaking out of school, plaintiffs have tried to subpoena her for trial, gone to her house, knocked on the door, somebody is there. They can fill you in on the details, but it appears that she does not want to accept services,
I understand, sir.
So that's all I got. This isn't us making stuff up. I know Mr. Pepperman well enough to know that he's just saying that. It's nothing personal, and I don't have.
Oh, yeah, and I don't think anybody's making anything up, but I mean, what do you do with a company? And they're in the production of alkaline water for consumer consumption.
That's right.
And they designate a receptionist as their quality control person.
Well, actually, it was Jeffrey Dosatel first, so as a production supervisor, as a quality control person. Well, I think what they were trying to do is the right thing, and everybody should be in charge of quality control. Everybody should be worried about quality control, and apparently they didn't worry enough.
That's a good argument. I will admit, that's a good argument. But my point is this, you don't put a person, a receptionist in charge of quality control, right?
I think they were trying to send a message. They were trying to empower their employees using job titles to encourage them to grow into positions. And this was a family company. It started out with a limited number of employees. They were promoting people. They really wanted to turn out a good product. Frankly, they drank the product. They drank the product even all the way up until the recall in 2021. So yeah, we fault them for not realizing that there was hydrazine in the water that they all were drinking.
No, I get that. And I do understand. In fact, one of them is a plaintiff in this case, right?
No, not in this case.
Okay.
Blaine Jones is a plaintiff in another case, and has a claim against the company.
And Mr. Jones was the gentleman doing the video?
Yes, Your Honor.
Yes, Your Honor. Okay. We have multiple videos, but I believe Blaine Jones was the one who testified in front of you live and also was in several videos.
Right. Anything else, sir?
Nothing further, Your Honor. Thank you.
What I'm going to do is, as far as the motions are concerned, I'm gonna rule similarly to my prior motion. I'm gonna deny it. And I think it's a great argument to make, and that's one for the jury. But for example, Patty Converse, she was reception, right? And they later changed her title to quality control. Well, it seems to me if you do that, you have an obligation to make sure she's qualified to undertake that type of responsibility. You just do, and I remember, I think she testified in the last round, right?
By video, Your Honor.
By
That's the
video.
blonde woman.
Yeah, I think she appeared to be a nice lady, and she was just telling the truth.
Well,
I don't know why she won't spend time with us.
Yeah,
Yeah.
well, I mean.
She seemed like a nice lady. That's my
Served her
recollection.
3 times. I'm gonna serve her again.
Served her once, we'll serve her again.
And wasn't Mr. Desatel, he had the prior experience at another bottling company, is that correct?
Yeah, I know. I think you're thinking
Mike
of
Bush.
Mr. Mike Bush.
Okay,
He was
that's
the
what
one-
I'm
He was the
thinking.
one in Nestle.
Yes,
Yeah.
okay, but I do remember the facts,
Right.
Yes, Sean, you do.
yeah. Over a year ago. 20 trials ago,
How many trials ago? 2?
yeah. Let's go to the next one.
We show the next one as document 530, and that's Affinity's motion eliminating number 9. This was a motion eliminating preclude customer complaints predating the complaint. We understand from the court's ruling this morning on the admission of other complaints that ruling would be applicable to this motion, and our arguments would be applicable to this motion. I don't have anything further to add.
Your Honor, I would agree with Mr. Odou. I believe you've effectively already denied this motion by virtue of our prior motion number 10, plaintiff's motion number 10.
Go ahead.
Thank you.
The next one we would show would be document 531, which is real waters motion eliminating number 10. And again, we believe that the court addressed this in plaintiff's motion number 10.
Right.
It's interesting. It's symmetrical.
Okay,
I mean, it would have all the same arguments, Your Honor.
all right, we'll incorporate those into my decision making and I'll go ahead and deny it.
You know, something, it's not, it wasn't number 10, but it was the one you dealt with before, Your Honor, that.
Yeah, we'll go back and figure out which one it was.
I can tell you which one it is. It is, number 21.
21.
Yes,
Thank
Your
you,
Honor.
Mr.
We believe this one has been
Yeah.
effectively denied as well.
After that, Your Honor, we show,
It's the same as ours, 21, effectively denied 9 and 10 for real water. And our arguments would be the same, though.
we agree.
That's the same reasons for 530 as well.
Yes. I think that takes us to real water 11, I think.
Yeah, that was 530 and 531.
All right. What's next?
We show plaintiff's motion for summary judgment number 3 that I think we've reached a stipulation on that one. We have reached a stipulation on that one. Let's document 535. And so the parties will finalize the stipulation and provide it to the court.
Is that correct, plaintiffs?
It's been.
Done this one?
Yeah, which one are you talking about?
I thought that was 535. The medical bills?
Oh, our motion.
Yeah.
Yes,
okay.
It was plaintiff's motion for summary judgment number 3, right?
Yes.
Sure, we can also just grant the motion to the amounts that are listed out in the reply, which are undisputed. That might be an easier way to get it done.
So, Your Honor, in our reply brief, we listed out the undisputed amounts, and if the court wants to incorporate those into an order, we can generate the order, or we can submit a stipulation, whatever's easier for the parties in the court.
I think more accurately, their opposition, they set forth what was unopposed in our reply. I think we agreed with them.
Yeah.
Okay. So,
So are we doing an order?
and for the record, I just want to make sure Tori's not confused. Right?
I'm confused. Are we submitting a stipulation or?
Why don't we grant it and we'll put the amounts in the order? That's the easiest way to do it.
We agree.
So granted, and the amounts will be in the proposed order?
Yes.
And we'll run the order by
That's what we'll do.
them, of course.
The next one would be document 522, real water's motion to eliminate precluded admissibility of the consent decree. There was no opposition.
That's 522.
522.
Yes. Was there an opposition, plaintiffs?
No, Your Honor.
Okay, just want to make sure. Granted.
The next one would be document 542. Real Water's motion for summary judgment on plaintiff Henry's wage loss claim. There was no opposition, and I think we have a stipulation.
I have 536 is next.
Did I miss one? 536?
Yeah.
I might have missed one.
I had 542 before 536, but
536 is next.
okay.
What motion eliminate is that, Tori?
That's Affinity Lifestyles, DBA Real Water LLC, Real Water Incorporated's motion in limine to preclude evidence or argument that plaintiff's pets were injured by Real Water, motion limiting number 11.
Okay, thank you.
And we're prepared to go forward on that. That argument will be presented by Mr. Kaufmann if we're doing document 536.
Good afternoon, Your Honor. Matthew Kaufmann for Real Water Plaintiffs. This is Real Water motion to eliminate number 11, sorry, document number 536. Basically what we're asking the court to do here is in their fact sheets, plaintiffs produced or claimed that some of their pets were affected by real water. During the course of discovery, plaintiff produced some some vet records for pets. For example, I believe it was Mr. Brown or Mr. Henry's dog who unfortunately had an aggressive cancer, is what the medical record revealed. There are medical bills produced for Daisy Way's parrot, all of which plaintiffs in their fact sheet claim are related to real water consumption. However, plaintiffs have not produced any evidence or any expert opinions that would tie those two together. And I understand, you know, plaintiff's position and the court's position about prior and subsequent incidences, but I think it's kind of a stretch to automatically attribute anything that's going on with their pets as being related to real water. Now, just the other day, I was thinking about this actually as I was preparing for this motion. One of my dogs threw up, and I was like, "Oh, okay." And about 30 minutes later, my other dog throws up. I think, well, they're probably related, but the second dog had eaten part of a toy, so clearly they were throwing up for two completely unrelated reasons. And how am I supposed to figure that out as a layperson? And I don't think that plaintiffs should be allowed to do that either. Just because their dog or a cat became ill does not necessarily mean it's related to real water. And I think it's speculative, and I think it's inviting improper lay opinions here. And then just very quickly, you know, plaintiffs are going to argue the motion is not specific, but we've cited to the specific things that we want to exclude. So I don't really think that's a well taken argument. And with that, I'll just reserve some time for rebuttal, Your Honor.
Thank you.
Your Honor, I think this comes down to two different areas of what we're talking about here. The first one is the prior incidences and the knowledge of real water related to these, and the FDA report, which is the FDA core report, which has been already stipulated to be admitted in this case, actually draws the connection between multiple dogs and cats and real water, and talks about the 14 dogs and 2 cats, and also lists therein the different symptoms that the dogs were or cats were having: vomiting, nausea, loss of appetite, and lethargy. And so as far as a prior incidences component of this, there's the FDA core report. There's also Casey Aiken, who was a real water employee at the time, who testified as to his own dog's illnesses related to feeding him real water and throwing up and the like, and actually being diagnosed with a liver problem there. So there's actual notice on certain things. And I think this is where the motion gets a little overly vague, is it just says all lay witnesses about pets. And so I think there's a little bit of a distinction between some of the different aspects. There's also real water complaints related to, I can't remember if it's Dorn or Fisher, who talks about her dogs also getting sick. That's actually part of a customer complaint, which is pre-admitted already as part of this court's prior ruling. So there are components of those where it goes to notice, and similar, the humans and the pets had very similar illnesses. The FDA reported the similar symptoms. So it kind of goes to the FDA and the prior notices under the progeny of the cases that we've already discussed here. And the second part of it is to the lay witness aspect. And we've kind of already discussed that. Mr. Pepperman discussed that it's perception of the plaintiffs observing their pets after consuming real water, noticing that their pets were not doing well, throwing up, whatever, and ceasing to provide them with real water and noticing an improvement. And so there is a part where they can talk about their own observations of this. And I think that's really where this falls. So I think there's the symptoms of vomiting, diarrhea, fatigue, loss of appetite. Those are things that are observable notices of symptoms that went away with the discontinuation of real water. And so that establishes a link that a lay person is perfectly qualified to testify to. So for all those reasons, we think real water has not demonstrated that this evidence, especially in the broad stroke that they seek to do, is really admissible on any ground. And in case it wasn't clear, it is in the FDA core report that has been pre-admitted, where the board.
You did say that.
Alright.
Here's my
Good
next,
enough.
here's my next question. When it came to, potential, well, I shouldn't say potential, but exposure to real water. It's my recollection, weren't dogs part of the, study? That's probably the best way to say it.
Correct.
Investigation.
Investigation, there you go.
Yes, and I think we, in our opposition, actually put the little chart that was on there. Shane, I don't know if you have that handy. It's on page 3 of our opposition, or Your Honor, if you have it in front of there, which it actually has the exact little chart in there that the FDA in conjunction with the Center for Veterinary Medicine actually included pets as part of their. It looks like Your Honor has it there.
Yeah, I have it right.
So yes,
There we go.
that's perfect. So yes, it was part of the FDA CDC investigation as well. That's in the core report. And they were asking the plaintiffs or the people who were reporting their illnesses to the CDC, the Southern Nevada Health Service, and that's the FDA. They were asking questions of, did your dogs also get sick? If so, what were their symptoms? And so that's where this also comes in. So for those reasons, Your Honor, that's why we think it's admissible evidence and their motion should be denied.
All right.
Threw her off.
Okay, sir, you have the last word.
Thank you, Your Honor. Just very briefly, no one's disputing that the court report discusses dogs or cats, but I think what's going on here is the conflation of specific and general causation. The fact that the court report references dogs and cats and that plaintiffs' pets exhibited generic GI symptoms, allegedly, is not enough to say, well, real water made them sick. And I think that's really what the difference is here. We're asking lay witnesses to basically say, well, my dog got sick because of real water. Well, I don't know what else your dog ate that day, to put it frankly. But, so I think that's the big difference here, Your Honor. This is about specific causation as opposed to general causation. And that's, I think, what the distinction we need to make sure.
Well, I can make a distinction for you on that specific issue. They're not making a claim for damages as it relates to the injuries or whatever suffered by the pets, right? They're not making a claim for that. And
well, I believe that'll be.
No, but they're not. They're not making a claim for I mean, I love dogs. I have 2 show dogs. And if I lost one of my dogs, it would be very unfortunate. Maybe I can make a claim for it. But if I wanted to get the money paid for my dog refunded, I'd have to establish it would be a different standard. And here's my point. And this is really important. And you talked about general causation. We had discussions on that at the last trial. But my point is this, and it's really very, very important because we don't want to confuse standards and medical causation when it comes to making claims and what the requirements are under the law. This is more epidemiological as far as findings are concerned. Secondly, the medical literature, it's my recollection, was very clear that hydrazine caused injuries to dogs, right? I remember. And then just as important too, and remember this, when it comes to prior events, our Nevada Supreme Court was very clear in the Krause case. You don't even have to know the exact nature of it. It was the lever, right? And then they said, we don't even know if it wasn't there language from Krause that says that. I know it is. I haven't read it in a year, but here's my point. When I made my decision when I dealt with those 6 factors or 5 or 6 factors, I went through all that and I looked at all Nevada cases, and this is a products liability case. And I thought it was pretty clear. And I don't mind saying that one of the reasons why I made the decision I made was also the findings of the FDA. Right? Did I say that? Yeah. And so anyway, and I just want to make sure I circle back to the motion. This is which one again?
Number 11, Your Honor.
This is, yeah, number 11, this is docket number 536.
To preclude evidence or argument that plaintiff's pets were injured by real water. I guess that would be motion eliminating number 11, right?
Correct.
Yes.
I'm going to deny that. And for the very same reasons, because we're talking about 2 different standards here. Just want to make sure I'm clear on that. And hopefully I clarified that for a reviewing court. So where do we go next?
542.
537.
Thank you for taking that.
You know what that?
I do not, I'm looking for 537.
537
Oh,
is
37.
lifestyles motions on number 12, then will be 538, which is motion eliminating 13, and then it's 542.
13, I think, is moot. Did you agree with that, Joel?
I'm sorry, Teddy, which one is
I
it?
think 13 is moot, isn't it?
Motion eliminating number 13?
Rev check?
Yeah, motion eliminating 13 is moot. We can withdraw that.
Are you withdrawing it or are you agreeing it's moot?
It's moot, whatever is easiest for the court.
So,
It's moot.
Withdrawn as moot.
So then number 12, are you now on, Joel?
Yeah, I gotta pull up 12.
We're making good headway, aren't we?
Yeah, we have 8 contested motions, including this one, I believe, that are left.
And for the record, we'll go to 445.
Oh, yeah, another good, sounds good.
I still have to get ready for tomorrow.
What time were we gonna break around? 4:40?
445.
Oh, 45.
Even what for?
At what time are we gonna meet tomorrow?
This one should be.
Anything that has business records in it is never quick.
And tomorrow we reconvene at 1:30.
Okay.
That's
good.
So we'll be-
So you'll be here in the morning too, I guess.
Yeah, we have a calendar call at 10:30.
And the
Well, you're number 1, so this is the firm trial setting, right?
Yeah, and
Right.
then there's a motion for settlement.
Do we need to be here, Your Honor, subject to, can we kind of do it now?
We can.
We got it here tomorrow. Anyway.
Yeah, they got a firm trial setting. You're number 1.
Then 9
Discovery
o'clock.
Commission by Zoom. No, it's not. Discovery Commission.
Because there's no reason to come back 2 times tomorrow.
No, Your Honor.
Yeah, they have the preferential setting and we've told everybody else that they're going on October 7th.
Everybody knows you're going number 1.
Your Honor, if we do the pretrial now then, and then pick up with 12, I don't know that we have anybody teed up to argue the last.
Yeah, we're doing really good, Mr. Odou. So we'll just do the pretrial now and then we'll break and we'll come back tomorrow. We'll start number 12.
Thank you, Your Honor.
Maybe we
Appreciate
can
it.
go through the list of what we're gonna do tomorrow too.
We can do
Yeah,
that
happy to
too.
do that.
We can do that too, but there's no need to argue anything. Okay. Let's go to the pretrial calendar.
I'm gonna move that for tomorrow and put it onto this calendar.
And so when do we start in this?
October 7th.
October 7th at 9:30. We have a preferential trial setting based upon age. That's my recollection.
That's right.
And you're number 1.
That's correct.
And you're number 1.
Your Honor, and you know, we're trying to expedite things, but I think there's gonna be between 40 and 42 witnesses. So I was joking with Julie, we try to do as many as we could a day, we will. But I think it's probably gonna take us at least 6 days to test, at least.
You know, and the thing, I'll be candid with everyone. I'm not even concerned about this case as far as efficiency is concerned, because it still has the record, I think. 29 witnesses in 1 week, right?
Yeah, I'm hoping to do better than that, Your Honor.
You need 45 in a week?
Yeah, I can't do 45. in a week. I don't think, but I do think if we start October 7th, we're hoping to get done by October 31st. That's our hope.
Yeah.
And by done, I mean verdict done.
I understand. Anything you want to add to that, Mr. Odou, or?
No, I think that's great, Your Honor. Since we're doing the pretrial now, we get a day or two to get our deposition transcripts into the court.
As far as designations,
Yes, Your Honor.
when do you want to agree to that as far as time now?
We'll get it done this week for sure. It's just a matter of.
They close the
meeting and
business Friday?
conferring. We're gonna meet and confer on Thursday. Could we get into the court on Friday? Or is that too quick?
In terms of the designations,
Yeah.
or we've already made our designations. So, you know, hopefully based on the prior testimony, we can agree on most of it.
We did before.
I don't know if we can get the agreed upon cuts and objections.
Yeah, that's fine. I don't wanna, kill ourselves, but. No, I was just gonna get the original depositions that we need to lodge with the court, get a couple of days for that, just to make sure that we have everything.
Oh, I know we've ordered our original depositions. If they haven't been delivered to the court, they will be. I shouldn't speak on the status of that. I'm not really knowledgeable at this moment on exactly where we're at in that process, but I know those will be delivered from plaintiffs to the court, well before the start of trial.
Yeah, ours will be too. I just don't have them like right now. So I don't want to have them considered late because we're doing a calendar call right now. That's all. We can have them to the court by the end of the week. That would work great.
You can. There's no problem with that.
We'll meet and confer on the deposition designations and come up with a plan for the court for tomorrow.
Okay.
So what do we have left for tomorrow?
Well, I was gonna ask that, Tori, do you have us granting plaintiffs MIL number 13 because of the non-op?
Do you know the docket number on it?
You know? This is the
Yeah.
jury notebook.
Oh, the jury notebook. You sure that was 13?
I got a
Oh,
plaintiff
we
MIL
haven't
number
gotten
13.
to that one yet. That's docket 561, plaintiff's motion to allow juror notebook and motion in limiting number 13 to pre-admit plaintiff's exhibits related thereto.
Right.
I got a non-op on that one. Did you oppose it?
Yeah, we're not opposing the jury notebook. We just have to get together and give you what we want on the notebook and meet and confer and get that done.
So can we put that one granted? So we don't have to worry about that tomorrow?
Yeah, that's no problem with us.
Okay, we'll grant it in principle. You have to meet and confer and agree upon the contents.
Yeah, just so you know what we're doing, we're doing a jury notebook and the cover is gonna be the 15 plaintiffs with their names. It's kind of like a program you use. Try to give the jury a way to get familiar with everybody fast. And then we have 4 exhibits that we've selected and we suggested they can select 4 exhibits.
Yeah, jury notebooks for years had been a modern trend and we kind of slowed down.
Yeah, these are, you know, they were hot about 20 years ago and then all of a sudden I haven't used one myself in forever.
And then for
What,
another-
14? Oh, you got something on MIL 14?
Yeah.
What's that? Okay, so we skipped that number.
Right, yeah.
So we skipped that one. So we got nothing on 14 hours. And then 16, you argued, and that one was took under advisement. Was that the same for 16?
And then 16 is on,
16 is under advisement,
15 we haven't argued for.
15 hasn't been argued, I'm not seeing a 14.
Okay,
Doesn't exist. That's why. Another potential like calendar maintenance thing that we could do is tomorrow at 9 a.m. There's a status check regarding Trevor Bell's settlement with Silver Springs. Do we want to move that to the afternoon?
Hey, Your Honor, can we move that to the afternoon just so we don't have to come down here just for that?
Yeah, and who's all involved in that one?
Well, there's been a settlement reached and I think the issue.
Well, Your Honor, that's
Minor.
actually just the status check on the, essentially, we did an annuity for the minor.
Oh, this is,
Minor is the
okay.
minor. We do not have the annuity contract yet to submit to the court. So maybe, it doesn't involve any other party but plaintiffs.
I understand.
If we could maybe continue it 30 days and
Find out what time we're coming down.
see if we have the annuity documents. It's all been funded and set up. We just need the documents.
Give us a date, Tori.
Okay, that status check date will be October 30th at 9 a.m.
Thank you.
Okay.
I still show 13 is back to do, right?
Third-
Tori, do you show anything on MIL number 7? These are plaintiffs. There's 17. Do we have a 17? 17 plaintiff?
Seven.
We don't have plaintiffs.
Okay,
Motion
so no
limiting
17.
number 7 is granted.
7 was granted.
How about 20?
We don't have one.
We don't have a 20.
Bring a motion.
I'm just trying to figure out why we're skipping these
Yeah,
numbers.
You didn't file.
Killing
There's
me.
numbers that were skipped.
The only ones I have open are number 12 and number 33.
Okay,
12 was Glenn Jones speaking agent. We did that.
Okay,
That one
that was
we got
granted,
done.
right?
15.
so we're missing 15
Correct.
from 33. How about 23? What happened with 23?
We don't have one.
Yeah, we're missing
It shows
15
on here.
and 15 and 33. Okay.
15 has not been heard yet. What other one are you asking about?
It said I have a list of the ones that we haven't heard yet that are listed in the court's order. We could do that if you'd like.
So what do you have?
So, I should document 537 rural water motion limiting 12. 542 rural water MSJ regarding wage loss. 551, the MSJ regarding Muntz and Watkins. 559 plaintiffs MSJ number 1, adulteration. 543 MSJ regarding Maynard, Gray Maynard's wage loss. 545, which is plaintiff's motion in limine number 16 that hasn't been done yet.
I'm saying 16 is done about 50.
Oh, I did miss that. I'm sorry. 544 is between 43, yeah.
Yeah, it's 15, not 16.
Yeah, that's rural water's motion 15. And then after 545. Let's see, I show an unopposed 546.
Which motion limit is that?
That is a motion for summary judgment regarding damages under NRS 4185. And I think there's a stipulation that we're working on with Brianna.
Did you go through plaintiff's motion limiting number 30?
We don't have 30.
Yeah, we do. It's the pre-admit photos of the plaintiffs. And there's a non-op, so I just wanted to see if that one could be granted. Taken off the list.
Yes, I showed that one. Let's see, I thought I saw that one for tomorrow.
That's 5, the photos, that's 5.
That's document 562.
Yeah.
That was, that's on the list for tomorrow.
I thought
You're
there was a
right, it's
non-op.
not opposed.
Okay, so we had that one granted, just so I can get the list. For the narrow.
Yeah, whatever you want to do.
Good. Non-op, if it's a non-op, we'll grant it.
Yes, John, no.
And for Tori's sake, which one is that again? Just to make sure.
Document 562, it's plaintiff's motion in limine number 30.
All right.
So I leave us with one.
What about
And
your?
then I also have, on the calendar, defendant and cross claimant Albertson's honestly joined our defendant in limiting number 28. Is that moot? Because they're out, right?
So 28 was granted and that
This is-
inclusive of their doctor.
Yeah, okay.
Is
So-
our position.
The joiners granted, or would it be moot? Are they still in?
They are, because that's the cross claim. They have a cross claim against Nevada Beverage, and that motion says that cross claim will be tried in a separate phase of trial, not part of this jury trial phase.
I understand. So the joinder is granted.
Yes.
Now we don't have any left.
Still have your 14, 15, and 16.
Rural waters 14?
Yeah.
Those are, I show those for tomorrow.
Yeah, we still have those from, we're trying to.
Yeah, I show those, document 544, real water motion limiting 15. Document 545, plaintiff's motion limiting 16. 562 is plaintiff's motion limiting 30.
Hasn't here 14 and 16.
Real water's 14?
That's 552.
That's tomorrow. 14 is 552.
Yeah.
What about 16?
Yeah, I show that. The value is document 545.
And that we don't have Dr. Gomley anymore, is there any movement on that one?
Dr. Gong?
That chart includes Dr. Gomley.
Oh, yeah, that's in 545.
Yes.
I don't know what the discussions are currently.
Okay. Motion for partial summary judgment on punitives. Last one I had.
Yeah, I don't think that's on the calendar.
That's not on the list. What,
We couldn't find that one.
Yeah, we couldn't find it on the calendar either. I can add it.
Yeah, okay.
And that's Real Water's motion for partial summary judgment on Kemp's punitive damage claims.
Yes.
what docket number is that, do you know?
I don't have it right in front of me. I'd have to quite research for it. But I will be adding that and it'll go on to tomorrow's calendar. I'll look up the docket number. And
Could be 547.
547.
Yeah.
Thank you.
Okay, good.
And I'll add that to tomorrow's calendar. And everything not heard today is just gonna be reset to.
Great.
Okay.
Are we done?
Thank you, Your Honor. Thank you so much for setting the time today.
Oh, no problem.
Thank you.
What time is it tomorrow?
Thank you, Your Honor.
Tomorrow's at 1:30.
1:30?
All right, and the 9 o'clock is off?
It's off.
Just do the calendar now, yeah.
We just do the calendar.
Is we heard this afternoon and staying with the status check, so we just got.
1:30, awesome.
And have you all got copies of the questionnaires? Last but not least.
Yes, we received some this afternoon.
Even,
I think the
yeah, we
last.
received some more this afternoon. I think we're up to about 300 questionnaires that were built.
Probably have one more batch maybe or no? I went down, what, 4 times?
Let's put, you know, right here.
Off the record.